Good morning. This hearing will come to order. Welcome to today's hearing entitled Amending Executive Order 12866, Good Governance or Regulatory Usurpation, Part 2. I want to welcome everyone to this hearing today on the role of the Office of Information and Regulatory Affairs, OIRA, in overseeing the development of regulations. The most powerful regulatory body, regulatory office in Washington is the rarely noticed Office of Information and Regulatory Affairs. OIRA was created in the 1980 Paperwork Reduction Act with a mandate to reduce the paperwork requirements of the American public. Within a few years of its creation, the Reagan White House had given expansive powers to the office to review all regulatory proposals by federal agencies. And predictably, an office supposedly created to reduce paperwork put standards and procedures in place that required agencies to generate mountains of paper. Congress and the White House struggled over the proper role of OIRA all through the 1980s. Various congressional committees believe that OIRA prevented agencies from complying with statutory requirements to clean up the environment, to protect the public, and to make workplaces safer. The Clinton administration's Executive Order 12866 involves some of the same aspects, resolves some of the aspects of that fight. This subcommittee took testimony from a former director of OIRA, Sally Katzen, in February. Ms. Katzen was the principal author of Executive Order 12866. She testified that the Clinton administration order assured that agencies carried more influence over the substance of a regulation than did OIRA. OIRA could ask hard questions, ask for more data or more clarity, but in the end, statutory authority and expertise was with the agency, and OIRA must respect that. Executive Order 13422 is a new chapter in OIRA's role and opens again some of the issues that were resolved in the Clinton administration order. Under this order, not just major regulations, but guidance is subject to review by OIRA. And the order creates a new requirement, and I understand, Mr. Aitken, you will testify today that is not really new, but it creates a new requirement, market failure, for any agency to promulgate any regulation. Market failure does not appear in any statute as a consideration in rulemaking, and in fact, Congress flatly rejected that argument that the market will work things out. Given time, if we leave it alone, the market will work it out. Congress flatly rejected that argument by enacting legislation that granted rulemaking authority. The order also requires agencies to compose annual summaries of the cumulative costs of proposed regulations, another requirement for rulemaking that does not appear in statute. And the order creates within each agency a regulatory policy officer who can smother regulatory efforts in the crib before an agency can even begin considering a regulatory action. The cumulative effect of all these changes is to seize for the President and OIRA power over regulatory efforts consistent neither with statute nor with the Constitution. Professor Strauss has it just right when he warns us that there are many potential hazards on this path. I want to hear what process was followed in developing this new executive order, what deficiencies in the Clinton administration order, Executive Order 12866, this new order is designed to address, and how OIRA intends to apply the various new requirements. I want to hear also the advantages and pitfalls of using cost-benefit analysis, market failure, and even a regulatory budget as a tool for regulatory policy. The power given to regulatory policy officers is especially troubling. RPOs are presidential appointees with political ties. OIRA speaks for the President, and OIRA has set out an economic standard as a guide to regulatory proposals, a standard unsupported by statute. RPOs will address that standard while also serving in agencies that have a statutory obligation that is entirely different from the values and preferences of OIRA, or at least may be. Unlike the Clinton administration order, Executive Order 13422 requires no disclosure. There are no transparency requirements to explain the actions of RPOs. Mr. Aitken, in your testimony today, you will sing the praises of transparency, but I think there are questions about how the RPO's role is consistent with expectations of transparency in government. Will we ever know in a pre-rule period what has happened who has spoken with whom, how language has been changed in any proposal, or what proposed rules were stopped in their tracks by an agency's RPO. What sort of discussions may occur between OIRA and the RPO regarding OIRA's expectations, and how would the Congress, much less the public, ever learn that those exchanges had occurred? Deciding issues that affect the lives of millions of Americans in secret is incompatible with our democratic traditions. And with that, I recognize my ranking member today, Mr. Sensenbrenner, for 5 minutes.
Yes, sir. As you can see, Sensenbrenner and Rohrabacher look a little bit alike there.
This fellow here.
Okay. You won't try to pronounce Rohrabacher, and I fully understand that.
The gentleman from California.
Well, I would say that it's a pleasure to be with you today, but I actually am taking the spot of Mr. Sensenbrenner, who is called away because he is serving as ranking member on the new Select Committee on Energy Independence and Climate Change. So I'm taking his spot while he's out doing some other things that are equally important. I'd like to welcome the witnesses, and I understand that many of them actually testified before Congress on this topic before this, some of them having testified before the Judiciary Committee in February. I'm also glad to see that the administration is here to clear up any misconception either side of the aisle may have about some of the proposals that have been made by the administration. I've served on the Science Committee for 20 years, so I'm fully aware of how science and research influence the regulatory process. I've also seen how several administrations have chosen to organize and oversee the regulatory process. In the past, each president has set up his own guidelines upon taking office. With that in mind, I think it's worth noting that we are here today discussing this issue in the 7th year of the current administration. Up until this point, the current administration has been operating under President Clinton's executive order. Furthermore, the new executive order that we are looking at today simply makes minor clarifications and leaves the vast majority of the Clinton administration's executive order in place, asking agencies to report work on market failure and cost-benefit analysis. Well, that they are already doing, they're already required to do this, doesn't seem like a great leap in a new direction to me. Also, if we are going to have a regulatory policy, and if we're going to have officers at these agencies who are making decisions, which is what the previous executive orders have required, it might be a good idea to ensure that they are accountable to someone. And ultimately, all executive orders only stand as long as the current president is in office. Thus, the voters will have a way to determine who they should elect as president of the United States, by what executive orders, and who they will re-elect based on the executive orders that come out of the various candidates. In all likelihood, the next president will modify or even replace the particular executive orders that we're talking about within a very short period of time, within just a few years after, or even a short period of time after the next election, so just a very short period of time from now. Viewing this topic in this light, I think that the issues that we will address here today have less to do with their policy implications and more to do with who issued these policies. That being said, I will certainly follow how this executive order is implemented to ensure that public health and safety are preserved and that there continues to be transparency and accountability in our regulatory process. And again, let me note this. When President Clinton became president, I was fortunate enough to be serving in Congress at that time. The first thing he did was eliminate every U.S. attorney fire every U.S. attorney without explanation, simply firing them. And there's been a big brouhaha about President Bush getting rid of several U.S. attorneys, and then but unfortunately, Mr. Gonzalez felt compelled to offer some explanation, which now has put him in hot water. President Clinton chose not to offer any explanations of that. Well, here we are in a similar situation where President Clinton was offered executive orders. This is his right to do so. And this president, 7 years into his administration now, is altering something that President Clinton did immediately upon entering in his term of office. And thus, there is now a attempt to call this into question. And I would just suggest that if it was any other president, or if it was past president was doing this, this would not be an issue because the president has a right to issue executive orders. And with that said, I'm looking forward to hear from the witnesses and proceed with our questions. Thank you.
Thank you. And there are no other members here, but if any other members of the committee wish to present opening statements for the record, we can receive them in writing and include those. Mr. Aitken, with that bit of advice, support openness, transparency, and accountability, but don't explain yourself or you'll get in trouble. We welcome your testimony today. Mr. Aitken, Steve Aitken is the General Counsel for the Office of Information and Regulatory Affairs, OIRA, the Office of Management and Budget. And for the last 10 months, Mr. Aitken has served as the Acting Administrator of OIRA. Mr. Aitken, your oral testimony is limited to 5 minutes, but your entire written testimony will be placed in the record. And after you have given your testimony, the members of the committee will have 5 minutes each to ask questions. And we do swear our witnesses. Mr. Aitken, do you have any objection to being sworn in? Okay. You also have a right to be represented by counsel. Do you have counsel here today? Okay. These questions are designed to put you at ease. All right. Please stand and raise your right hand. Do you swear to tell the truth and nothing but the truth? Thank you, Mr. Aitken. You may begin.
But we note for the record that the people on this side of the hearing are never sworn in that way.
Thank you, Mr. Chairman. Chairman Miller, Representative Rohrbacher, and distinguished members of the subcommittee, thank you for giving me the opportunity today to testify before you on Executive Order 13422. I am Stephen Aitken. For a 10-month period, starting in June of last year and ending at the beginning of this month, I served as Acting Administrator of the Office of Information and Regulatory Affairs. I've worked at OMB for nearly 18 years. Except for my service as OIRA's Acting Administrator, I've served in the Office of the General Counsel at OMB, first as an Assistant General Counsel and then as a Deputy General Counsel. I'm testifying today in my capacity as the former Acting Administrator of OIRA. Earlier this year, the President issued Executive Order 13422, which made several amendments to Executive Order 12866. The most important of these amendments relate not to the regulations that federal agencies develop, but rather to the guidance that federal agencies develop. In addition, on that same day, the OMB Director issued the Bulletin on Agency Good Guidance Practices. This is the final version of the bulletin that OMB issued in proposed form for public comment in November of 2005. As I note in my written testimony, the draft bulletin received support from a broad and diverse range of commenters, and the bulletin reflects good guidance principles that are found in the FDA's good guidance regulations and that have been supported by the Administrative Conference of the United States and by the American Bar Association. The bulletin and executive order share a good government goal: to improve the way that the federal government does business by increasing the quality, accountability, and transparency of agency guidance documents, including the opportunity for the public to review and comment on guidance. The good government improvements that are made by the bulletin are reinforced by the recent order, which provides for a relatively informal process whereby some, but by no means all, of the significant guidance documents that are developed by agencies will be submitted to OMB for interagency review. In addition, the recent order makes several additional good government improvements. There has been some confusion in the press and elsewhere about these changes, and I would like to address those. First, concerns have been raised about the order's provisions regarding regulatory policy officers. First, these officers are not new. When President Clinton issued Executive Order 12866, he directed each agency head to designate a regulatory policy officer. In addition, while the recent order specifies that these regulatory policy officers will be presidential appointees, the case is that for most departments and major regulatory agencies, they already were presidential appointees subject to Senate confirmation. In addition, concerns have been expressed regarding the recent order's discussion of market failure. Before explaining what this amendment does do, I want to explain first what it does not do. First, the concept of market failure is not new to Executive Order 12866. Instead, it's been an integral part of that order since President Clinton issued it in 1993. In the order, as issued by President Clinton, the President referred not once but twice to the, quote, failures of private markets, unquote, as a justification for regulation. That's the same thing as a market failure. Second, the recent order does not make a market failure the only basis on which an agency can justify regulatory action. Instead, the order expressly allows an agency to identify as a justification for regulatory action any other significant problem that the agency intends to address. That's what the recent order does not do. What it does do is include in Executive Order 12866 references to three classic examples of market failure, namely externalities, market power, and lack of information. These three examples are not new to the implementation of Executive Order 12866. In fact, in 1996, the then OIRA Administrator, Sally Katzen, issued best practice guidelines to the agencies that included a separate discussion of market failure. And those guidelines discussed these three classic examples of market failure. Some have expressed the concern that the recent order could prevent agencies from issuing regulations to protect public health and safety, but this is not correct. Many of the most significant regulations that agencies issue are, in fact, in response to market failures. For example, environmental pollution is a classic example of an externality market failure. Another type of market failure stems from a lack of information. In response to this kind of market failure, the Food and Drug Administration issued a regulation that requires nutritional labels on packaged foods to display the amount of trans fats in them. This rule was not driven by a specific statutory mandate, but by the market failure of lack of information. Finally, I would like to mention that late yesterday, the OMB Director and the OIRA Administrator finalized a memorandum to agencies that provides them with questions and answers to assist them in the implementation of the recent order and bulletin. A copy of the memorandum was forwarded to the subcommittee late yesterday, and it's being posted on OMB's website this morning. This concludes my opening statement. I would welcome any questions that the subcommittee has.
Thank you, Mr. Aitken. And I want to announce a policy this morning. In the first couple of meetings of this subcommittee, I have had a hard time overcoming my Southern mother's teaching that interrupting people was bad manners. I think all of us struggle with it as adults to figure out what part of what our mother taught us we need to ignore as adults. But we do need to keep fairly close to the time allotments. You were fine. You were just a few seconds over. Mr. Warbacher was actually just a few seconds over in his opening remarks as well. In this opening round, I'll ask for questions for 7 minutes, my questions and your answers. Mr. Warbacher for 7 minutes. If any other members appear, they will have turns to ask questions for 5 minutes. But we do need to keep fairly closely within that time limitation, and I will bring the gavel down as necessary, hoping that in fact C-SPAN is not broadcasting this and my mother's not watching it at home. Mr. Aitken, you spoke in your testimony, in your written testimony, you said the OMB believes that federal agency guidance should be developed, issued, and used through an agency's adherence to procedures that ensure quality, transparency, public participation, coordination, and accountability. All those sound laudable. I agree with all of them, but I'm wondering how those standards were applied in actually developing this executive order that we are discussing now. Were there meetings with which agencies about them? When did those occur? Were there any public comments sought? Was there correspondence with outside parties? Could you tell me briefly what kind of consultation occurred in developing this order?
Thank you for the question. The order was developed in accordance with the standard process that the executive branch has for the development of executive orders, and that process is set out in an executive order itself. I believe the number is Executive Order 11030 that's been in place for several decades, and it provides for a process whereby OMB consults with other agencies about a proposed executive order, and the executive order could be proposed by an agency, another office, by OMB, and those consultations then feed into an internal deliberative process that results at the end of the day in a proposal being made to the President, and it's then the President's decision on whether to move forward with the proposed order or not. That standard practice, which was followed here, does not involve putting out a draft of an executive order for public comment. That's simply not the practice that's been applied for decades in the development of executive orders. And in this case, the agencies were consulted per the standard process, and their views were requested and taken into account.
You said that there was not a draft put out for public comment, and I assume that you didn't get it just perfect the very first time, that there were various iterations of the executive order. Am I correct in assuming that?
Yes, I can't really get too much into the details of the executive order process in regards to the substance or the discussions that occurred internally. But yes, as is the case with executive orders, and OMB does handle that process, so I'm familiar with it. Executive orders typically go through a number of drafts in response to comments and further thought.
Okay, when you say you can't comment, is it because you are not familiar, you don't know?
It's because it's just an internal deliberative process, and the standard practice is not for the executive branch to reveal the internal deliberations that resulted in an executive order.
Mr. Aitken, we have a point of disagreement about what Congress's authority is and what the internal deliberative process protects from disclosure to Congress. And I'm afraid if you take that view, we may end up having several issues, several hearings about this issue. So it is your intention not to discuss further what the procedures were in developing this draft, the various drafts, who was consulted, what documents were generated, were there internal memoranda, correspondence, emails? Were there such documents?
Oh, yes. The standard executive order process in the OMB General Counsel's office is the lead within OMB for the interagency clearance of executive orders, so I'm very familiar with that process. Okay. Typically involves the submission by an agency or an executive branch office to OMB of a proposed executive order, the circulation of that proposal to agencies and offices who would be interested in that order for their review and comment.
But you do not intend to testify today to who made which suggestions, observations, criticisms, concerns. You view that as not within the information that Congress may seek of the executive branch? Because that is a bad course we're on, if that's the view you take.
Okay. I think what I'm offering, and again in my capacity as the former acting administrator, and as a long-time OMB career employee, is that Those deliberations, which ultimately lead to the proposals to the President for action, are internal deliberative communications. They're privileged. We would not release those, for example, in response to a FOIA request or in a litigation. And my experience has been that we have not released those deliberations to the public, or that we've been requested or provided those in the past. It's just not my experience.
That's been my experience too. But a request from a committee of Congress is not the same as a FOIA request. There are cases, as I'm sure, I hope you're aware, maybe you aren't aware, the courts have dealt with this issue. There is an internal deliberative process. The court says it is a very slight, it has very slight weight. If there is any need for the information, the concern about finding the truth overcomes any concern about protecting confidentiality. And if there is any suggestion that there was an improper, that the executive agency action was based upon any improper consideration, there is no privilege or immunity at all. This is not a FOIA request. Now, I hope, I'm afraid that we are going to have another hearing to discuss these processes, and I certainly think that we are going to now request of the agency a great many documents. So I would urge you to, when you get back to your office this afternoon, look at the law on internal deliberations and consider carefully that this is a committee of Congress asking, not a FOIA request.
I understand that, and I will do so. I mentioned the FOIA in part just because of the congressional recognition in the enactment of FOIA of the importance of confidential deliberations for improving government decision-making. Also, it's my experience that the executive branch over the years, through decades, has not received requests from Congress for the internal deliberations leading to executive orders. So for me, this is kind of an unprecedented experience, and it's just, being here today, I'm not in a position to be able to.
Why you did what you did strikes me as something Congress has every reason in the world to ask.
Mm-hmm. And I'm here. I'm happy to answer any questions about the order itself. And I think both with respect to the order and other issues, I think it's best, or at least I'm here to be able to explain what these provisions mean, why they're there, and I think at least the confidential deliberative process tries to protect the ability of people to have a dialogue, and my sense is that
and I know that you have a distinguished legal education, and I know that you have studied the law of privileges, and you know that there's a tension between encouraging confidentiality, encouraging candor, and the need to find the truth. There are some privileges that are absolutely respected. Well, actually, there are very few that are absolute. The attorney-client privilege, for one, is a very strong privilege. But the courts have struck a different balance with respect to internal deliberations. That the courts perhaps respects the confidentiality of the candor of those discussions over a concern based or an inquiry based on idle curiosity. But if there is a need to know, that whatever privilege there may be gives way. Again, I urge you to look at your law books this afternoon, and I assure you, I feel confident we will be asking for further documents based on our conversation just now. Well, I have many questions that you may or may not answer. Was anyone outside of I'm sorry. I do not want to. I have, in fact, violated my own rule slightly. Mr. Warbacher.
Well, I think we need to interrogate you into your what mental processes you were going to when you violated that rule that you'd set down. We need to question whether or not that was a planned move or whether this is just something that you just happened to do because you were being the chairman and you were asking some questions. But we need to get you under oath to testify to see if you actually were motivated to break that rule that you just had. But with that in mind, Mr. Now it's Aitken?
Aitken?
Aitken, okay. Mr. Aitken, you've worked for the Office of Management and Budget for how many years?
It'll be 18 years.
18 years. So you were actually there and overseeing legal type of analysis of things that were going on even during the Clinton administration. Is that right?
That's correct.
Did anyone ever put you under oath and start inquiring about the internal deliberations during the Clinton administration when they were trying to issue executive orders, or was that normally accepted that basically the president has a right to issue an executive order and then has a right to have internal deliberation as to what that executive order should say?
My experience was that OMB had not received requests, at least my recollection, had not received requests during the Clinton administration, or even during prior years in this administration for the internal deliberations regarding an executive order.
For example, in the Clinton administration, you have the wording of the executive order: each agency shall identify the problem that it intends to address, including, where applicable, quote, the failures of the private markets, end of quote, or public institutions that warrant new agency action, as well as access to the significance of that problem. Now, that wording was changed, which seems to be a big problem now. Instead of the failure of private markets, seems to be that the big problem is that they changed that to say each agency shall identify in writing, so they're identifying this in writing now, the specific market failures as compared to failures of the private market, and then we're requiring them to do it in writing rather than just in an oral report. Now, I guess we really need to know whether changing that wording, whether or not there were memos going back and forth, and we've got to make sure that you spend a lot of your time now searching those records to see about who wrote that and whether or not that person, you know, may or may not have had the best interest of the country at heart when he wrote that, as compared to when the Clinton administration wrote those words, failures of private markets, that nobody questioned that. I guess that's what we're talking about today. And your recollection is that nobody bothered to ask anybody about the wording of failures of the private market as compared to market failures when you worked at the OMB under President Clinton. Is that right? So
that's correct.
No one requested any information on that. Would you be surprised if there were directives issued by a political party that every committee and subcommittee should find something that they can issue ominous-sounding statements about and requesting voluminous information of the administration, trying to catch the administration in a mistake and then making it into more than a mistake, more than just going over a minute, but a calculated attempt to go to break the rules? Would you be surprised if a group of people who are running for political office might try to use the Congress as a forum to create a false impression for the voters in the next election? You don't have to answer that. That's fine. Thank you very much. You know, I'll just have to say that what we're talking about today and what we're going through today is totally consistent with what's, as I say, is happening in other committees. And President Clinton fires every U.S. attorney, everyone, immediately, without question, and nobody raises an eyebrow because they know that he has a right to fire those U.S. attorneys. And the President has a right to issue executive orders. President Clinton issues an executive order, talks about the failures of private markets, and of course nobody raises the issue, but this president changes the wording to say market failures and requires it in writing, and all of a sudden now we've got all of these requests for documents. You know, when the Attorney General started answering questions about what was the President's prerogative, they found that he didn't say exactly the things that were right in describing why the President had made his decision, even though everyone acknowledges the President has every right to make that decision, and now they've made that into a big brouhaha. I'm not necessarily someone who likes this Attorney General or even likes this President, to tell you the truth, but I can certainly believe that we need to be tackling real problems rather than political posturing. I would suggest that there's a pattern here. The pattern isn't that we've changed the word of failures to private markets in an executive order to market failure and require it in writing. That's not the pattern. The pattern is that we are challenging the President's authority, hoping to find a mistake in when he answers that question and then making a lot of political hay about it. I appreciate you being here. You're not a Republican or Democrat appointee. You are actually a professional, having served in a high place in both the Clinton administration and Republican administrations. So let me thank you for your professionalism, and let me note that I am intentionally not going over my time, and this has been calculated now to make sure that that the failure of the chairman to go for his time is highlighted. So I'll quit right there, Mr. Chairman.
Actually, Mr. Rohrbacher, I went over 2.5 minutes. If you'd like to go on another 2.5 minutes, you go right ahead. All right. Mr. Aitken, I assume that my staff will punch me in the ribs when it comes close to 5 minutes. I know that you've expressed some concern or reservation about telling this committee some of what the administration, OMB, considered in issuing this executive order, and I had somehow confused transparency with candor. But can you tell me at least when the first draft of this proposed regulation was circulated and to whom? Who saw it?
The order had been in development for some time. I don't have a specific recollection of when it was first circulated or to which agencies. That would be typically done by a career employee within the OMB Counsel's office in consultation with others. And so, apart from it being done in the standard process, I don't have a recollection exactly, at what time or exactly to whom, but it was a standard process that was used.
Approximately what month and year?
Since I haven't looked into that, I hesitate to say, just because I just haven't looked into that history recently.
Was it circulated to anyone outside of the administration?
So far as I know, no. That was not.
No one outside the administration was shown or there was no discussion with anyone outside the administration about the proposed executive order.
I'm not aware of any such discussions. I can't say that they didn't occur, but I'm not aware of them.
Okay. Who within the Office of Management Budget or OMB or any other agency of government was involved in developing the draft or changing the drafts as drafts went forward?
In OMB, it would be a variety of offices are involved in executive orders depending on the subject matter. Because OMB in the standard process sends a recommendation memo to the President on them, it receives fair level of clearance through a number of offices. And so, again, the standard process was used, but I don't have a recollection of exactly, who all was consulted, although it was, as typically the case, it was a broad range of people within OMB.
Okay. Mr. Aitken, my understanding is that we didn't specify you as a witness that we wished to. That's nothing personal. But we asked OMB and OIRA to produce a witness who could talk to us about the process, how this was done. It is somewhat surprising, knowing that that's why we asked for a witness to be sent forth, that you are so unfamiliar with the process, when that's exactly what we told you we wanted to hear about.
My understanding was that when this hearing was first raised as a possibility in early March, when I was the acting administrator, there was naturally an interest in my testifying. But when the hearing was then moved to late April, and then when Ms. Dudley was sworn in as the OIRA administrator, my understanding is that OMB did reach out to the subcommittee staff to ask whether the subcommittee wanted me to testify, as I was no longer the acting administrator. My understanding is that the response that we received back is that the subcommittee did want me to testify, even though I was no longer the acting administrator.
And we understood the reason you were being offered was that you were there at the time, that Ms. Dudley couldn't talk about it because she wasn't there at the time. But I'm not sure there's much further to be gained by this. Your statement in your testimony, OMB believes that federal agency guidance should be developed, issued, and used for an agency's adherence to procedures that ensure quality, transparency, public participation, coordination, and accountability. Do you believe that those considerations, those goals, should not also apply to developing an executive order? I tell you what, why don't you answer that in my next round of questioning. Mr. Rohrbacher.
Well, thank you very much. You were there during the Clinton administration. Did President Clinton discuss, when he changed this wording to his executive order from failures of private markets to whatever it was before that, to now it's been changed to market failures, did he ever discuss that with any other interest groups in this town?
My understanding from the testimony that Ms. Katzen provided in February, I believe, is that, and she was the OIRA administrator at that time, is that she, according to her testimony, did have discussions.
Oh, she did?
That, according to...
So you mean the president, before he issues an executive order, actually talks to people outside the government? What kind of influence could they possibly have? My gosh, people outside the government are trying to maybe have an input into what government policy should be in terms of executive orders? Don't you see this as a threat to democracy in this country? No, you don't have to answer that. Were there documents ever requested about these discussions that President Clinton had with the outsiders when he came up with the phrase failures of private markets versus market failure?
I'm not aware that there were any such requests.
No documents. Now, but you don't know. You said I'm not aware, so we might have to request those documents as well, Mr. Chairman, of what happened during the Clinton administration to see if, my gosh, there were some incredible, insidious interest groups at work there, too. Let's see. Now, let me ask you this. You've worked both Clinton and Republican administrations. Is it your understanding that when you talk about executive orders, which is what the president is given a right to do under the Constitution, that the process that he develops, he thinks, is the best way to develop an executive order, that is pretty well left up to the president to decide what process he's going to have and what people will be in that process, as compared to having, let's say, the legislative branch in our Constitution suggesting they have the right to establish that process?
It has been the process that has been established by the president, and
based on constitutional authority granted to him. Is that right?
That's correct.
Does the Constitution permit the legislative branch to determine that for the president about the processes and have to have approval on that?
I wouldn't want to express an answer here just because
Okay, well, I
I'm
would
not
suggest
familiar
this,
enough
that
with it.
what we're talking about here is not the policy. I think the founders of the Constitution wanted us to be talking about policy, not trying to catch somebody as if they made a mistake in the process of how they determined that policy. Because one is where you destroy people and which stifles debate on policy, and the other approach is that you're discussing the issue at hand and trying to dissect what is best for the country, what policy is best for the country. And I think our founding fathers were very, very astute when they understood that politics might get in the way if we ended up discussing policy or a process rather than policy. And unfortunately, again, I see this disturbing, ominous trend in this town where people don't want to discuss the policy, but they want to catch somebody in a mistake while trying to recall the exact process of how a policy was decided upon, instead of just discussing whether that policy is a good policy or not. And if this was just happening in this subcommittee, I think that we would just sort of shrug our shoulders and say that this is not, this is something that's very legitimate here. Somebody just really wants to go down that road. But it seems to be happening throughout the legislative branch now, as compared to what happened, of course, during the Clinton years, when no one suggested the president didn't have these rights to make up his own mind in a process that he had established. So with that said, I appreciate your testimony, and I appreciate your service to the country. You're obviously someone who is takes your job very seriously, and you're the type of person that is not a partisan. You've worked hard for both Democrat and Republican administrations, and I'm sorry that quite often people like yourself get caught in the middle of different political power plays. Appreciate it.
Mm-hmm.
Mr. Orbach, you can take that 2.5 minutes any time that you would like. We seem to have stumbled on the only area that was not the subject of congressional inquiry in the last 6 years of the Clinton administration. There were 2 subpoenas issued by the Government Reform Committee a day for every day Congress is in session for the last 6 years. There were 4,000 pages of documents produced a day in the last 6 years for every day that Congress was in session. Mr. Aitken, let me make it clear to you, and I don't think that you mistake, that you have any doubt about this. Consultation is a good thing. We urge that. I hope you did talk to people. I hope you talked to people within the government. I hope you talked to people who deal with the government. What we want to know is what was said, that it be open, that there be a debate and a discussion, but it not be in secret. And that's why I'm asking the questions. I want to know what the concerns were that this executive order was designed to address.
And I can address that. As I indicated in my prepared testimony.
But that's why I asked the question: who was involved in the discussion, and what they had to say, and just describing generally what the concerns were and the objectives were does not get us at what the concerns were in this order, and that's why I'm asking the questions.
Okay.
There are other parts of the order that you've testified that market failure is not a new consideration. And as I understand market failure, it's the argument that the market hasn't failed. If we just leave it alone, it's going to fix the problem without Congress doing anything. Is that basic, or a regulatory agency doing anything? Is that basically the idea behind market failure?
As the 1996 best practices guidelines that Administrator Katzen issued explained, the rationale of market failure, which is one but not the only rationale for regulatory action, is that sometimes the government needs to step in because private markets are not addressing a situation. For example, in the FDA nutritional labeling rule.
So the way I describe the concept of market failure is essentially right. The market hasn't failed if we leave the market alone, it's going to fix the problem without any intervention by government. That's the idea behind market failure being a criterion. Has the market failed? Is the market not going to fix this on its own? That's what market failure is, right?
That's correct. If the markets can address a certain situation, then it's not a necessary for the... Yes.
Okay. I was part of the debate last week, and I think we'll have this debate replayed again and again, on whether shareholders should have an advisory vote on executive compensation at public corporations in America. And the argument against it, the argument against the legislation, was the market will fix this. Now, that seems to me to be a market failure argument. And every time that Congress enacts legislation to protect public health, to require FDA to inspect and assure sanitary conditions, and that there aren't public health consequences of what is being put on the marketplace, Congress has decided that the market is not working sufficiently well, and we need to do something about it. So it seems that whenever we've given an agency rulemaking authority, not just rulemaking authority, we've directed them to make rules, to carry out a statutory mandate. Congress has already decided the market is not doing this well enough. And usually over the express argument that the market is doing it well enough. Now, can you tell me, is there a clear, rigorous test that we can look at, that we can understand for when the administration, the executive branch, the various agencies, OIRA, the RPOs, will apply to determine if the market has failed and the government needs to intervene through regulation?
Okay. In terms of statutes, if Congress has directed an agency to issue a regulation, then the agency must issue the regulation. There's nothing in the executive order, either as issued by President Clinton or the recent executive order, that overrides any statutory directions to agencies. If Congress has made the decision that regulation is necessary, the agency must issue the regulation. The issue of market failure comes up in a situation in which an agency has discretion. Congress has not made a decision that the agency has to issue a regulation. Instead, the agency has permissive regulatory authority, and the question is whether the agency decides in its discretion to exercise that authority. And as reflected in the 1996 guidelines that Administrator Katzen issued, and in OMB's Circular A4, which we went through public notice and comment on, the criteria for market failure as a rationale addresses whether there's a problem out there that, one, if a problem exists, two, is it because the markets have not worked to address it, and three, is it something that the markets could not address? If that's the case, then that rationale for regulatory action would argue for the agency to act. However, there are other rationales apart from market failure, which the executive order in the recent amendment recognizes that an agency... Mr.
Aitken, can you complete this answer at the beginning of my next round of questions? Mr. Rohrbacher, sorry.
Well, I'm not a stickler. I'll let you sort of have an extra couple seconds there. I'm not going to throw the book at you if you break the rules.
All right, Mr. Aitken, if you'd like to complete it on Mr. Rohrbacher's time, that'd be fine.
That's the type of courtesy that makes this government work, unfortunately. Hope everybody understands that. The point I just made, that is. I had an answer to the chairman's question from his last question.
I was just concluding by saying that the guidance that's been out there since it was far back as at least 1996, the guidance that Ms. Katzen issued, describes the situations in which market failure can provide a justification for regulatory action. Again, as the original Executive Order 12866 provided and as the amended one provides, market failure is not the only justification on which regulatory action can proceed. It can occur because Congress has directed an agency to promulgate a regulation, and it can occur to address other problems that the agency has identified. That's it.
Well, thank you for that answer, and let me note that President Clinton issued the executive order in question here, September 30th, 1993, which seems to be, if memory serves me, actually very early into his first term of office. And this president has permitted that executive order to stand until very late in his administration. Seems to me that's perhaps similar to the fact that when Bill Clinton did change this early on into his administration, as I say, there doesn't seem to have been any of the inquiries made at all into his process of what he used, how he came to the decision to issue his executive order. No documents were mandated, no questioning of his motives, only maybe perhaps a discussion of the executive order itself. I don't remember that discussion, but it certainly wasn't an accusatory discussion. It was probably a discussion of the issue itself. That might be the same as when President Clinton fired every U.S. attorney then in position of authority when he became president. Again, no one questioned whether the president had a right to fire those U.S. attorneys and to hire his own people. These are people who serve at the pleasure of the president, as granted by the Constitution of the United States. No one asked the president, no one came in and put people under oath to try to find out if they could determine whether there was any loss of memory in the process, trying to get people and charge them with all kinds of malicious intent if they didn't remember exact details and conversations. And so there seems to be this change of strategies here, and that during the Clinton years, Republicans were not pushing on this and issues like that, and now when we have a president of the United States who's a Republican and it's getting close to an election year, now we seem to have a focus on other elements rather than policy. We focus on process and trying to see if people's memories are exactly right, see if we can catch them in a mistake. I'll have to tell you, it'd be hard for me. I can't speak for the chairman or other members of this body, but it would be very difficult for me to answer questions about how I came to a determination as to what my position was going to be on specific issues of the day, whether it was legislation or various issues that we handle. It would be very difficult for me to try to search back and find out exactly when I decided on something. And I think that really does break down the actually goodwill and comedy that we have here in the Congress, because people have to assume that we're going to debate the issues and not debate whether somebody is being what someone's motives were, and that's one of our rules of thumb here in the House. But I guess that doesn't apply when we're trying to talk about the president versus the legislative branch, executive branch versus the legislative branch. With that, thank you again for your service as being a bipartisan person who worked in both houses, or both administrations, Democrat and Republican, and tried your very best. And certainly, we're not trying to catch you on some lack of memory or making a mistake of memory.
Hello again, Mr. Aitken. I had really hoped to announce the new policy of being stricter with the time limitations without naming names on who had abused my Southern manners, and I will stick to that intent, despite obvious goading. Mr. Aitken, I agree that if I were asked about why I voted for something 3 years ago, trying to reconstruct my thinking at the time would not be easy, and I couldn't do it on the spot. But on the other hand, if I had been sent forward from a government agency to answer specific questions as to one in that agency who would know it, I would expect to be prepared. I would expect to refresh my recollection. I would expect to look at the documents. I would not just show up.
Well, that was not the case in terms of my coming here. I did prepare. I prepared as I had prepared for my testimony in February before the House Judiciary Subcommittee, which was on the same day, in fact, just after the hearing that this subcommittee held. I was not aware in coming here that I would be asked specific questions about who was consulted or what the timetable was for the development. I came here prepared and submitted lengthy, comprehensive testimony regarding the issues in the bulletin, regarding the reasons the bulletin was issued, regarding the issues in the executive order, and I, consistent with my professionalism as a career OMB employee, I prepared to the best of my ability for testifying today.
Let's move on to the transparency considerations again. And we all seem to like transparency, or at least the word, and then we have different interpretations of what it actually means or requires. The Clinton executive order that apparently somehow escaped being the subject of congressional subpoena, perhaps because it was in the first 2 years of the Clinton administration, did put in place transparency protections. Isn't that right? With respect to OIRA's decisions.
The executive order does include transparency provisions. Many of those transparency provisions had been in effect for a number of years during the prior administration.
And it includes showing an original draft of a proposed rule that had come from the agency and how it was changed. Isn't that right?
That's correct. Under the disclosure procedures.
And it required showing what outside parties had commented and what they had to say, what the correspondence was between OIRA and the outside parties. Isn't that right?
Under the executive order, for rules that are under review, there are requirements which we adhere to in OIRA for the notice of when meetings are requested from outside parties. Anyone can request those meetings. They're posted on the OMB website. I can say that during my 10 months, we received a number of requests for meetings, which, so far as I know, we always granted if we had time. And I attended.
Essentially, all the questions that I've asked you about how this executive order was decided upon are questions that would be public record, would be public with respect to a rule that had gone through OIRA under the Clinton administration executive order. Isn't that right?
I'm not sure I understand the question.
The questions I've asked you about who was consulted, what they had to say, how was the draft changed, those are all questions that would be public under, with respect to a proposed regulation under the Clinton executive order. Isn't that right?
The distinction is that the OIRA doesn't review executive orders.
Okay, I understand that distinction, but if the process I've described, the questions I've asked, those are public based upon transparency concerns with respect to proposed rules, right?
Under Executive Order 12866, President Clinton and this President has continued disclosure procedures about OIRA's reviews of regulations. I'm not aware of any President, and I believe that the executive order on the executive order process was established by President Kennedy. I'm not aware that any President has establish a process where the President is going to have his executive orders subject to public comment, or is going to release the drafts, or is going to, whether it's President Kennedy, President Johnson,
I understand
Nixon,
the distinction you're making between executive orders and regulations. And you're saying this executive order does not apply to regulations. With respect to regulations, with respect to Bush administration's new order, there are now powers given to regulatory RPOs at each agency, in which regulatory policy officers, which of these transparency requirements under the Clinton executive order would apply to decisions made, deliberations at the agency level by the RPOs? None of them would they?
The executive order, as it was originally issued by President Clinton when he required agency heads to appoint regulatory policy officers, did not have any disclosure procedures regarding the regulatory policy officers' activities, and that continues today. So since President Clinton issued the order in 1993, there have been no disclosure provisions regarding the regulatory policy officer.
I'm out of time, but you can assume that I'll ask further questions along these lines. Mr. Rohrbacher.
Well, let me note for the record that I'm not opposed to transparency at all. I mean, this is to the degree if the executive order that we're talking about has in some way decreased the transparency, then that's an issue that we should talk about. That's an issue we should talk. We shouldn't be talking about who discussed the issue of transparency with the president. We should discuss whether transparency in and of itself is an issue that is right or wrong, and whether the executive order went in the right or wrong direction. That is a totally legitimate area of discussion, and I would support more transparency requirements. However, I may be right or wrong in that. That's just my inclination. For example, if we had the same transparency requirements, if we set the same standard for members of Congress, we would have to say that members of the executive branch would have a right to query members of Congress as to who they spoke to, every single person that they spoke to, about any legislation, about specific pieces of legislation that would come up. We're making policy too here. And does the executive branch have a right to query us under oath to find out who we talk to, or does the American people have a right to know exactly where we stand? I think American people have a right to know exactly where we stand on an issue, which half the time members of Congress, as you know, try to obscure exactly what their positions are to try to make sure they're not making any enemies. So I would be very supportive, Mr. Chairman, if there's something in this executive order that hurts transparency, we could work on that and try to pass some legislation that would insist on transparency. But let's discuss that issue. Let's not discuss how some decision is come to. Now let me get back to that. Now, Mr. Aitken, do you think that congressional demands, and this goes because I may be supportive of those congressional demands for transparency. Do you think congressional demands for specific internal communications within the executive branch would curb the discussions and people wouldn't be quite so frank in their discussions on an issue if they knew everything was going to end up being public? And would that be, in the end, to the detriment of the public more than just would that have a negative impact as compared to a positive impact of transparency where we know all the discussions that were going on?
I think I would like to address that in terms of the confidentiality of the deliberations, and the importance of preserving that confidentiality is so that people can have frank and candid discussions. And Congress recognized that when in 1966, in enacting the FOIA statute, it preserved the deliberative process privilege. The courts have upheld that. It's important for people to be able to discuss the issues. If people internally cannot discuss the issues in a frank manner, decisions are
Look, I will tell you that I agree with that, but I will tell you on another committee, actually this committee, but on another subcommittee, we were dealing with reports that were issued by a federal so a member of the government, someone who worked for the government, issued a report on a specific decision that needed to be made, and does that person, should we then, when the administration is trying to make up its mind on something, should we then know what was in that report? I happen to believe in transparency because I happen to believe, and I've backed up the Democrat demands, to see that report. And I don't think that would in some way hinder the debate within the administration if they knew that people, when they've asked their opinion of various people, professionals like yourself, what that opinion was when it was written down. Now that's different than we're talking about private deliberations, I think, but maybe not. I mean, clear that up for me.
I'm not familiar with the situation you just mentioned in terms of the report.
Okay.
But I can say that having worked at OMB for 18 years in the counsel's office where these issues come up quite regularly, that it is important as it would be with a judge and a law clerk. I clerked twice. I think judges expect the confidentiality of their
Especially from
deliberations.
professionals. So if we have a professional who's over at a department or agency and we ask for a report, I frankly think that should be public record, and I would oppose the administration keeping that secret. However, it may make that public employee less, let's say, willing to be totally expressive of his points of view if he knew it's going to all be public someday. Is that right? And then
that is the concern that underlies the deliberative process.
Thank you very much.
Mr. Rohrbacher, you just used 20 seconds of the 2.5 minutes that you've got coming after. Mr. Aitken, you said earlier that RPOs were not new creatures of this executive order, that they existed before. What additional authority is given RPOs under this order?
As I noted in my prepared testimony, the recent order makes two relatively minor amendments to the provisions. One concerns the regulatory plan. Under the original issuance of Executive Order 12866 by President Clinton, it was the agency head who had to personally approve the regulatory plan. Under the revised order, it's either the agency head or the regulatory policy officer that would sign off on the agency's regulatory plan, which is the agency's once-a-year compendium of the agency's most important regulatory initiatives. Also, the executive order, the recent one, provides that either the agency head or the regulatory policy officer has to sign off on a commencement by an agency of a rulemaking.
Okay. So the RPO can determine when agencies, the professional employees of an agency want to initiate rulemaking, the RPO can decide, no, we're not going to do that. That's correct, right? That's the power of the RPO now under this order.
The order provides that in an agency, it's ultimately the presidential appointees who have to decide what regulatory activities the agency wants to engage in. This is not a new principle to the executive branch. I know that in the transition from the first President Bush to President Clinton, one of the first things that was done by the incoming OMB director, Leon Panetta, was to issue a memo to all agencies saying that there was a new president and agencies are not to issue new regulations unless they're approved by the agency head who's appointed by the president or by somebody else who's been appointed by the president. And that's to reflect the fact that it matters who is elected president, and in the executive branch, it's not solely the career employees who have the authority to issue regulations or decide how governmental power will be organized.
And I don't think we want to be entirely controlled by bureaucrats. We do not want government by bureaucrat or by platonic guardians. We do want the democratic processes to matter. But what are the transparency requirements, provisions for RPO decisions not to initiate rulemaking? Do any of the transparency provisions that apply to OIRA apply to the RPO when the RPO determines not to initiate rulemaking? Will anyone find out that the agency wanted to initiate rulemaking and the RPO said no?
Just as in the case of the memorandum that Director Panetta issued at the very beginning of the Clinton administration, there is no requirement in the executive order, nor was there any requirement in the original issuance of Executive Order 12866 for there to be disclosure requirements for the regulatory policy officer or even for the agency head and the agency head's activities regarding, say, the development of the plan.
We have enjoyed on Mr. Baird. Mr. Baird, do you have any questions? I just gave back a minute and a half.
Okay. The core of this issue seems to be, I'm interested in Mr. Aitken's comment just a second ago, if it matters who's elected president. It surely does. But the Constitution puts the legislative authority in the hands of the Congress, and if congressional intent statute is usurped by the executive, is it your understanding of the role of the executive that they are to execute faithfully the laws enacted by the Congress, or that the executive has the responsibility under the United States Constitution to usurp or circumvent those laws if they so choose?
Agencies must faithfully execute the laws that have been enacted. As a career government attorney, that's been my job, to ensure that agencies faithfully implement the statutes that have been enacted. And if Congress directs an agency to issue a regulation, the agency has to issue that regulation.
Then when you say that it matters who's elected president, what does that mean?
Congress in statutes, for very good reasons, does not always specify in each last detail exactly what kind of regulations an agency should issue or has to issue. Therefore, because there are complex issues, because there are policy issues that have to be resolved, and perhaps because there was not enough consensus within Congress about which policy should be pursued, Congress has provided discretion to agencies in implementing those statutes. And that policy discretion, as the Supreme Court has recognized in the Chevron decision, does allow agencies to make policy judgments, and those judgments are appropriately can reflect the policies of the president, whoever the president may be, when those
If your understanding of the Constitution or the authority of the executive versus legislative branch, if you're counseling somebody, one of these RPOs, about the process they use to formulate their decision, is it your counsel that they seek first to understand the executive position on a regulatory matter, or that they seek first to understand the congressional intent on the regulatory matter, and which of those is paramount if the two conflict?
The analysis would begin on any regulatory issue on how Congress has spoken on the issue. Every agency, in order to undertake a rulemaking, needs authority, statutory authority, to carry out that rulemaking. Congress sometimes provides permissive authority, which the agency can or decide not to exercise, or Congress, in other instances, mandates that an agency pursue a regulation, and in some cases, Congress mandates with great specificity the contours of that regulation. So the first issue for an agency would be, what has Congress said? Has the Congress mandated that we issue a regulation or given us discretion?
But isn't the crux of what part of what we're asking about here is, you just mentioned the first issue for an agency. One of the concerns is, what if the RPO feels more beholden to the administration than to the congressional intent? And if there's no way of tracking how that happened,
the executive branch has to comply faithfully with the laws that are passed by Congress.
How do signing statements fit into this? Does a signing statement by the executive somehow exculpate them from complying faithfully with the, or unfaithfully, as the case may be, with congressional intent? In other words, so you're saying on the one hand that the executive branch must comply with congressional intent, but this administration has used signing statements at unprecedented levels. If a signing statement is made by the president, does the executive branch agency then comply with the statement of the Congress as modified by a signing statement, or as intended in the original text by the Congress?
I'm not really, I didn't come prepared to talk about signing statements and the relationship of signing statements and regulatory action.
Okay, I can understand that, but I will express concern that I would hope that the agencies are complying with the Congress, not with the intent as modified by a signing statement. So your testimony to us then is that you believe that the statutory language as enacted by the Congress takes precedent. Let me say it differently. Let's suppose a president were to suggest to his people that they just really don't like very much a law passed by the Congress, and therefore what they would like to see is for an RPO to find any way around the law as passed by the Congress, rather than interpreting the intent of the Congress. Would that be an appropriate use of executive authority or an inappropriate use?
an agency must comply with the law. As the Supreme Court discussed in the 1984 decision on the Chevron case, Congress sometimes speaks very precisely on a particular issue. If that's the case, the agency must follow the congressional direction. There are other times when Congress has spoken but has provided discretion to the agency on whether to act or on how to act.
So let's suppose we create a continuum and we say, on the one hand, Congress has spoken quite clearly. Would it be inappropriate for an executive, for the president or one of his designees to say, Congress has spoken clearly, but we're still not happy with it. Therefore, we would like this agency to find a way to circumvent it and not promulgate a regulation. Would that be inappropriate?
I'm sorry, if you could make that a short summary answer. We are now out of time, and we do need to vote in a moment. Leave to vote in a moment.
As the Supreme Court said in the Chevron case, if Congress has spoken on the precise question at issue, the agency must follow the congressional direction.
And it would therefore be inappropriate. You're not quite answering my question. It would therefore be inappropriate for an executive officer to say to an agency, do not follow the Congress's directive. Mr. Chair, I know we have to vote, but if you have more questions, go ahead. I'm sorry.
I don't, not before voting anyway. Do you think you could answer that in a sentence?
Would it be simply yes or no? Would it be inappropriate for the president or his designees to tell an agency, Congress had this intent, we would like you to try to find a way around that intent? Yes or no, would that be inappropriate?
It would not be appropriate if the Congress has spoken precisely on all the issues. Often it is the case, and it's been my experience over the years, including during the prior administration, that Congress has provided policy discretion. And so one of the issues that often comes up is there discretion within the statute that provides policy officials leeway to go one approach or to another approach? And that's often a discussion that arises regardless of who is the president.
Thanks.
I think we really do. Mr. Rohrbacher cannot come back after votes, and I want to offer my condolences and those of all the members of the committee on the loss of your brother. I know you need to get back to California to that funeral. Do you want to take some of the time and sprint to the floor to vote if you wish to ask a few more questions?
Okay, well, it usually takes us a couple minutes to get to the floor, so I'll make this just a couple minutes worth of questions, so we'll have plenty of time to get to the floor. So what we see here is an ominous trend. I mean, this is there's a pattern here. First of all, President Clinton got rid of all the U.S. attorneys immediately upon taking office. It's ominous, of course, when this president gets rid of 7 of them later on, but that trend, that sort of, and then we see here a presidential executive order issued by President Clinton, and nobody got to ask whether or not he had consulted outside people on this and put them under oath and actually require all the documents and people to have good memories about who they talked to about this executive order. And now you let it slip. You were there. Mr. Panetta issued an edict that the good-hearted, honest public employees of the various departments and agencies couldn't issue any regulations till these political appointees actually got in place and were able to make the final decision. I smell a real problem here. I think that maybe there should have been hearings under Mr. Panetta's edict. Who did he discuss that with, that we're cutting off the rights of those good-hearted, honest public employees to set regulations down? This is getting a little bit absurd, and I would suggest that, now let me ask, you've had a lot of experience, you've been around longer than most people in this system. Do the presidents usually try to, when they're marking out their policies, isn't one of the considerations maintaining presidential authority and prerogatives?
That is correct.
Now, that was President Clinton or President Bush. I mean, Democrats, Republicans, are they all act that way?
That's correct.
All right. So
when the president sort of is suggesting that he doesn't want to make all private deliberations available to Congress, but we should discuss what the final decision is rather than the process he went through, isn't that a type of an argument that Democrat, Republican presidents all would basically agree upon?
It's certainly been my experience that those presidents have, over the years, made that argument.
Right. And let me note that you have worked for Republican and Democrat presidents both, and there is no, and you're saying that with an experience and having been loyal to both presidents of both parties. And so I think that this hearing has been good in one respect, that we really have had a serious discussion of some of the fundamental issues in terms of separation of powers of our country. And I think that that's important as to what you would expect employees to do and people to do in various departments and agencies and how it works out. And I said, that's been a very good discussion. Trying to question the motives of people, of how they have come to their conclusions in that discussion, is not appropriate. We recognize that in the legislative branch. We have made it a rule of thumb that we do not question the motives of someone who's presented an argument on the floor of the House, and that can actually, you can have your words taken down if you question the motives of someone. But we want to have an honest discussion of the issue at hand. That means you discuss the policy and not the process that someone has gone through in order to come to that policy conclusion. That type of goodwill, I think, is something that should be reflected in our overall democratic process. Unfortunately, when we get into this type of why did you come to a decision and who did you talk to, and if you make any mistakes in remembering exactly how many conversations you had, we're going to get you, or if you forget to put one document in, you're going to be prosecuted for it. I don't think that leads to, it doesn't benefit democracy and does not benefit the people. And usually these things start happening as we're leading up to a major and an important election. With that said, I thank you very much again for your service both to President Clinton and to President Bush, and for giving us an understanding of how the process works from the inside.
Mr. Aitken, you were dismissed. Thank you for being here.
Thank you.
I need to go vote. We all need to go vote. I could sprint back, and then I'd have to sprint back again after about 15 or 20 minutes of being here. Or I could, it'll be about an hour, and we can go uninterrupted. What is the preference of the next panel? Well, yeah, your consideration of whether I should sprint or not is not really the issue. Why don't I return in just a few minutes, take some testimony, and then I'll have to leave again. Thank you. Committee stands in recess. We will resume. Quickly on the schedule, we are the full House is now finishing a vote. After that, there will be a motion to reconsider, or no, excuse me, a motion to recommit, which will allow a 10-minute debate, followed by another 15-minute vote. So probably we'll be able to go about 15 or 20 minutes, and then I'll need to run back again. And at that point, I'll be there for 3 additional votes, and it'll take me about maybe half an hour, maybe 20 minutes before I can get back. But it gives us a chance for all of you to begin and probably complete your initial testimony. Mr. Strauss is the best professor at law at Columbia Law School. He's a nationally recognized expert in administrative law, constitutional law, legal method, and legislation. He was a member of the faculty when I was a student. It is his great good fortune that I am not today seeking vengeance for having embarrassed me in Socratic method, as I never took his course, as I could not imagine how I would ever need to know anything about administrative law. But I will note for Professor Strauss that I will be asking the questions today. Our next witness is Dr. Robert Hahn, the co-founder and executive director of the American Enterprise Institute's Brookings Joint Center for Regulatory Studies, which must feel sometimes like having Mr. Rohrbacher and I sit beside each other, which examines leading-edge issues in law, economics, regulation, and antitrust. Dr. Gary Bass is the founder and executive director of OMB Watch, and has worked extensively on federal budgetary, program management, regulatory, and information policy issues. And finally, Dr. Richard Parker, a professor at the University of Connecticut, an expert in administrative law, environmental law, regulatory policy. He chaired the Regulatory Policy Committee of the Administrative Law section of the ABA and has written on the use of cost-benefit analysis and OIRA. As each of you know, your oral testimony is limited to 5 minutes, but your entire written testimony will be placed in the record. And after the entire panel has given their testimony, the members of Congress, members of the committee, which probably will be me only, and I'll do a series of 5-minute blocks of questions. We'll have 5 minutes each to ask questions. And so I'll put all of you at ease as I did Mr. Aitken. I'll now ask you all to stand. Do any of you have any objection to being sworn in? Is anyone represented by counsel today? Okay. Now that you're at ease, you may raise your right hand. Do you swear to tell the truth? Do you swear to tell the truth and nothing but the truth? Thank you. We'll begin with Professor Strauss. Excuse me, let me amend that. Dr. Hahn, I think, is under a time constraint. Dr. Hahn, if you could testify first. Okay, Dr. Hahn will go second. Professor Strauss. I understand your microphone is not on, Professor Strauss, so you need to do that.
I'm sorry also that your colleague had to leave, because in his opening statement he made what seems to me the central point, at least from the perspective of my testimony, which is that it might be a good idea to ensure that they, and he was referring to the regulatory policy officers, are accountable to someone. And the issue that I mean to talk with you about is to whom they're accountable, and what the congressional stakes are in that. The Constitution makes the President the overseer of all the very duties that you give government agencies, but equally clearly, it seems to me, it permits you to assign those duties to those agencies and not to the President. And for those duties, he's not the decider, but rather the overseer of decisions that others make. The important point, in my judgment, is to preserve this distinction between presidential oversight, which is entirely appropriate and constitutionally commanded, and presidential decision. The assignment of decisional responsibility to others is a part of those laws to whose faithful execution the President must see, and when he fails to honor this rather subtle distinction, he fails in his constitutional responsibility to take care that the laws be faithfully executed. The executive order we're discussing amends the long-standing Executive Order 12866 in several ways, and I want to focus on 4 language changes that, in my view, threaten the difficult but necessary balance between politicians and experts, between politics and law that characterizes agency rulemaking. These are amendments to Section 4 and 6 concerning the regulatory plan, both of which diminish the effective control over regulatory decision by the agency head that you have put in charge of agency business, and increase the President's control over regulatory outcomes, an increase that, in my judgment, requires congressional authorization. You heard Professor Katzen, the previous administrator of OIRA, when she was here at the last hearing, talk to you about the step-by-step increase in presidential controls. Executive Order 13422 is another step in that direction, and from my perspective, a hazardous one. The first change added these words to Section 4C1 of the Executive Order, applicable equally to executive and independent regulatory commissions. Unless specifically authorized by the head of the agency, no rulemaking shall commence nor be included on the plan without the approval of the agency's regulatory policy officer. This language purports to confer legal authority on the regulatory policy officer to control whether agency rulemaking occurs, subject only to a specific countermand by the agency's head. Prior provisions of the order, President Clinton's order, merely hinted that denial of a place on the regulatory plan would preclude rulemaking, and in my efforts to track this issue, I've never heard that it had happened. Your own provisions for the regulatory agenda in SUBREFA are quite specific that presence on the regulatory agenda is not a condition of valid rulemaking. Where did the President get the authority to impose this condition, much less to put it in the hands of a junior officer? The second change I invite you to focus on subtracted these words from Section 4C1. The plan shall be approved personally by the agency head. So the agency head is no longer imagined as having general personal responsibility for his agency's important business. That's for the regulatory policy officer, and the agency head just gets a veto, one whose exercise will doubtless be impeded by its specificity, visibility, and vulnerability. When the regulatory plan was first rationalized, it was rationalized as an aid, and it seemed to me an entirely appropriate aid, to the political heads of administrative agencies, requiring career staff to reveal their priorities and plans for rulemaking to agency leadership in the same way that the dollar budget process does. So it sensibly injected the agency's political leadership into the picture before matters got set in bureaucratic concrete. But now that's been diverted to someone else. The third change added this language to Section 6A2. Within 60 days of the date of this executive order, each agency head shall designate one of the agency's presidential appointees to be its regulatory policy officer, advise OMB of such designation, and annually update OMB on the status of this designation. The important elements to note here are that a presidential appointee is a person the president, not the agency head, gets to hire and fire. And the repeated references to OMB make clear who will be overseeing her performance. You may hear verbal promises that these presidential appointees will be of the kind that the Senate must confirm, but of course the language doesn't say that, and even if it did, the fact would remain that the president, not the agency head, is in charge of the RPO's continuing tenure in office. The fourth change, also in 6A2, just confirms this pattern of displaced responsibility and division of authority. It subtracts the prior requirement of the section that the regulatory policy officer shall report to the agency head. Of course, the statute creating presidential appointee within an agency will itself embody some kind of reporting relationship. But I think you can see how neatly this change echoes the others that I've mentioned. The order purports to confer legal authority on a junior authority in each agency whose identity must be coordinated with the White House to control the initiation of agency rulemaking, and it seems to be intended its continued processing within the agency. Conferring this kind of legal authority is Congress's business, not the President's, and its authority I'd urge you not to grant, because it diffuses political authority within the agency that you generally entrust to the agency head. Congress, as well as the President, has political relationships with the agency head. While the president can cashier agency heads whose work he doesn't like, that comes at a high political cost, including having to get the Senate's agreement on a successor. As a well-connected friend told me, I personally watched 2 agency heads tell the president to pound sand. They wouldn't do what they were told, and the president knew they had the political capital to win. Junior officers appointed under close White House supervision, knowing that they can be dismissed by the White House at any moment, won't have this political capital. There isn't as much chance that firing them will have political costs for the White House. They're not ever going to be telling the president or OIRA to go pound sand.
Thank you, Dr. Hahn.
Thank you, Chairman Miller, for hearing. I'm going to try to focus on some of the substantive issues in the executive order. My co-author Bob Lighton and I have studied and written about regulatory issues for, dare I say, more than 2 decades from an economic perspective. And it's from that perspective that I approach the analysis of the President's new our bottom line is that the new order is not as revolutionary or far-reaching as the critics make it out to be. And indeed, the actual requirements or additional requirements of this order are modest. I'd like to make the following 3 points. First, expanding the executive order to consider guidance is a positive step. Second, the changes regarding regulation are not likely to substantially increase an agency's analytical burden. And thirdly, the expansion of presidential influence over major regulatory policies is on balance a good thing and will serve to enhance accountability. First, treating guidance like regulation is a good thing. The new Bush executive order includes regulatory guidance when its impact is likely to be significant. We don't know the impact of most guidance, but we do know that regulatory agencies issue a lot of it. For example, the FDA has an online list of over 1,500 guidance documents that are currently in use. The new Bush order requires that each agency evaluate the need for and consequences of guidance, helping to ensure that it's reasonable. I don't think that's a lot to ask for. Some critics argue that oversight is not needed because guidance is non-binding. This is simply wrong. Consider a situation where an agency says that it's acceptable to use blue paint to comply with the regulation, but is silent on whether yellow paint might be used. I would imagine that you would see a lot more firms complying with that regulation using blue paint, or complying with the regulation using blue paint rather than yellow paint. That, to me, looks a lot like a regulation. And to borrow a phrase, if it looks like a regulation and quacks like a regulation, then I think it should be treated like a regulation. Our second point is that the executive order's changes regarding regulation are not likely to substantially increase an agency's analytical burden. The new EO adds some requirements for new regulation. For example, some critics have complained about the requirement that an agency provide a written rationale explaining why it's regulating. But this isn't really a new thing, as you heard earlier. The only real difference between the Bush order and President Clinton's order is that the Bush order specifically requires that rationale to be in writing. In general, the requirement of a rationale, which was first added by President Clinton, is important and should be applicable to all regulation and guidance. If agencies don't have a good economic rationale for regulation, you and the public deserve to know that. Furthermore, the Bush order stops short of requiring that the agency specify a clear economic rationale. It simply needs to specify a rationale, any rationale. Third, the expansion of presidential influence is likely to promote greater accountability and better economic policy. I'm running out of time, so I'll be brief here. The basic idea is one that you mentioned earlier, that unelected government civil servants are not necessarily in the best position to be making tough policy choices. Indeed, they may suffer from a kind of tunnel vision, as Justice Breyer noted in his book, Breaking the Vicious Circle. If I were to have any complaint about the President's executive order. It's that it does not go far enough. In particular, it excludes independent agencies like the Federal Trade Commission, the Federal Communications Commission, and FERC from review. Professor Cass Sunstein and I have argued in a law review paper that these independent agencies should be subject to regulatory review. In addition, I would also suggest subjecting significant guidance documents to a broadly based benefit cost test. This would give regulators and the public a better understanding of the likely economic impacts of guidance and could also improve guidance. In conclusion, we think the new executive order on regulation represents a modest improvement over previous orders. It's also consistent, by the way, with a global trend towards featuring a more prominent role for economic analysis in informing regulatory decisions. Thank you, and I'd be happy to take your questions.
And I think now I need to go vote. Dr. Hahn, I understand you probably cannot be here when I get back, but I'll be gone for probably around 20 minutes. And I apologize, this is simply the schedule we're on. There's only so much we can do about it. But I will be back as quickly as I can. Thank you, and we will be in recess. Zoom. Dr. Gary Bass will testify next. Dr. Bass.
Appreciate the opportunity to testify and for you to run back and forth. Wonderful of you. Let me start by, just posing, I suppose, a question for the record, and that is, if those people who are so supportive of the executive order changes say that it's so minimal, then what was the purpose of doing the changes in the executive order? And so I have a sort of rhetorical question on that point. If it really was nothing, then why so late into this administration was any change made? I also want to just open by indicating that if Professor Strauss raises constitutional questions about the executive order, you can bank on it. I mean, that is a critically important point. And even if there aren't constitutional problems, this is bad policy. So let me start with the whole point that no one has said. The objective should be to actually get rid of this executive order. And whether Congress chooses to directly approach that or whether it chooses through the power of the purse to withhold funding for the implementation of components of it, that is the strongest recommendation that I could possibly make. Now, within that context, I think that in the immediate side, transparency and accountability, as you, Mr. Chairman, have mentioned, is essential. So let's turn to transparency as a theme. First of all, let's talk about transparency in the entire regulatory process overall. At best, I would describe it as walking into a dark room and the government handing you a flashlight when you could flip a switch and have floodlights instead. It is not very transparent, is the point I would make. And now you add in the enhanced powers that Professor Strauss talked about of the Regulatory Policy Officer, where there is no transparency. You are totally in the dark, not even a flashlight. So if Congressman Rohrabacher and Mr. Aitken believe in transparency, it seems to me one place to start is to really provide some transparency for the entire regulatory process. Now, I could spend some moments about the OIRA power and what has happened, as well as the power that would exist because of the RPO at the agencies. But instead of spending my time on that, I want to directly talk about specific recommendations for transparency. One sentence before that, though, that I want to mention, and that is most of the discussion about OIRA's power has been in the context of the executive order itself, what they do during the regulatory review, that is, the formal review process. What is striking is the informal part of it, meaning what I would call pre-rulemaking. The dialogue that occurs between OIRA, or the White House, and the agencies before the formal process ever kicks in is critical to any kind of public accountability. And right now, there is no transparency on that process at all. And in fact, by the changes in the executive order, we have enhanced more power in that pre-rulemaking stage, and yet no transparency. So let me turn to recommendations. First, let me do it in two ways. One is for the agency itself, and then turn to reviewing authorities such as OIRA or Small Business Administration. And I'll only use 5 under each because I was always told you can count up and still pound your hand and advocate for it all at the same time. So 1, at the agency level, it's essential to have disclosure of who these new RPOs will be, or not new, the new enhanced power, but the political appointees could be new, who they are, what their responsibilities are, what the procedure will be within the agency. For example, when does a regulatory activity commence? What is the definition of that? How do you reach the person? All of that kind of information should be publicly available, conspicuously publicly available on the agency website. Second, since we now have a political appointee and it has raised significant questions, as you heard from Professor Strauss, what really needs to be done is to disclose all decisions by the RPO and the justification for that decision. It is not just about what is permitted to go forward, but also what is stopped, and for that matter, what is permitted to go forward but altered in its approach. Third, we should have an annual report to Congress summarizing those activities. It should also be in the unified agenda, which is published in the Federal Register, so the public can see what's happening. But the documents that are exchanged internally to the agency should be sent to Congress in this annual report. And fourth, in my point on the agency, and I won't go to 5, all substantive communications, written or oral, outside the government or outside the agency, including from OIRA, should be docketed in the agency rulemaking record. Moreover, for those activities that don't go forward, a new docket should be created about communications related to those that don't go forward. Let me turn to OIRA and other kinds of reviewing entities. First, if a reviewing entity such as OIRA is now going to play a substantive role in rulemaking review, it should be treated under our Administrative Procedure Act as involved in the rulemaking. And all of the various kinds of requirements that go with that should be held to OIRA. If it is really just going to be not the decider or the overseer, as Professor Strauss tried to distinguish, then maybe it doesn't apply. But it's clear that they're getting much more engaged in the substance. Secondly, all substantive communications, written or oral, particularly from outside of government, before, during, and after the OIRA review, should be docketed not only at OIRA, but again back at the agency level. Thirdly, OIRA should establish a government-wide standard for tracking rulemaking so that the public can follow it from the beginning all the way through. You can't today. It is extremely difficult. And then, fourth, the OIRA website, which is incredibly important that administrators, starting with Administrator Katzen, moving to Administrator Graham, have helped with transparency. But the website itself needs enormous improvement. It should be searchable. Right now, it's just a long list of things to look at. Finally, the log that is used at OIRA for meetings with external players is at best inconsistent in what you get. Sometimes there's no title even of what the subject is. Almost never do you get anything about what the content of the meeting was about. You may get a list of participants. In any case, it needs to be complete, it needs to be consistent, and it should be linked with that website on what the regulatory activities are happening, so you know what's going on. I recognize that this adds burdens to agencies, but in an environment like this executive order, transparency is fundamental and essential to true accountability. I want to just thank you, Mr. Chairman. This is now your second hearing. This is wonderful to find oversight, and I hope the oversight leads to action in terms of legislation. Thank you.
Thank you, Dr. Bass. Dr. Bass, I know that your red light was on. You said you had 5 points. You made 4 and didn't make 5. You wish to make the 5th. All right. All right. Dr. Richard Parker. Dr. Parker.
Thank you. Mr. Chairman, I appreciate this opportunity to share with you some observations on Executive Order 13422. Over the past 20 years, I've had a chance to observe the regulatory process from a number of different vantage points, from the private sector, from within agencies, both in the Reagan administration, the Clinton administration, and from academia. The only perspective I haven't had is your perspective, the perspective of the Oversight Committee, but that's obviously a very, very important perspective. And I have to say that, when I view this issue vicariously from your perspective, it seems to me that the entire institution of OIRA review of agency policy is distinctly problematic, and EO 13422 should be viewed as a small but significant step in that already problematic direction. What do I mean by that? Well, by extending OIRA oversight to guidance documents, we focused on the transparency, but not only does EO 13422, but all the executive orders have hugely expanded the power of an agency that has basically no scientific and technical expertise to shape policies that often have a very important scientific and technical component. It extends the power of an agency that has a troubled history of acting as a conduit through back channels for special interests, to guidance documents now beyond regulatory documents. And I just wanted to echo what Dr. Bass just said about this problem of informal reviews. When I was talking to old friends from various agencies about what I should say in this hearing, just open-ended question, what worries you most? The first thing that came out was these informal reviews, which basically are backroom things that they are instructed not to report to anybody, but which turn out to be very influential in shaping rules from the get-go. So I just want to second Dr. Bass's comment on that based upon what I've been hearing from the trenches. The RPO, I think, issue has been dealt with extensively. I won't elaborate on it except to say I support it. The issue is that basically, where are we going and why are we here? White House intervention in rulemaking is not required by the Constitution in the area of that we're talking about. It's not mandated by any statute. And the question arises, given the costs to transparency, to expertise that we've been talking about, what is it that justifies this kind of intervention at all? I'd like to just sort of ask to think about this from a cost-benefit standpoint. We've seen the costs. What are the benefits? And I will have to say that procedural, procedural steps are very hard to quantify. Their benefits are very hard to quantify. And if my colleague were still with me, I would point out that there are regulatory critics who basically zero out benefits of procedures that can't be quantified, and so by that standard, the entire institution of a OIRA review would have to be assigned a zero benefit and would fail cost-benefit analysis. I can't play that game because I favor the inclusion of qualitative benefits, and so I have to do a little more work. But we need to talk about what is it that OIRA is bringing to the process. And it seems to me that if you go back through history, the reason that OIRA was brought in, and the thing that has been driving this entire dynamic from the get-go has been a profound skepticism of the competence of agencies and certainly of their even-handedness. Going back to the 80s, there was this view that, EPA is full of environmental wackos who, think the polar ice caps are melting or something. And OSHA, just full of these zealots who just can't stop, pushing out regulations. We have to rein them in. If you recall from the 80s and the 90s, in particular, when these institutions were getting entrenched, there was an endless litany of horror stories of regulatory abuses. And I'll tell you, I was bothered by this litany, and I started investigating some of these stories. And I published the results of my investigations in two major articles, and I can only summarize that here, but I can tell you in a nutshell that what I found is that these stories basically can't be verified in most cases. Many are gross exaggerations. Some were just complete fabrications, and I could give you an example. There are some stories, of course, that are true. I mean, in any case, there are genuine problems. But there has been no documentation of a pervasive problem of agency overzealousness that would warrant this institution in the first place. The other great sort of foundation stone of this regulatory skepticism that gives us a OIRA review has been a series of, three really major studies that look broadly at regulations, and all of which and all done by regulatory critics, all very widely publicized over a period of decades, and all coming to essentially the same conclusion, that while regulation is overall beneficial, there are many regulations that fail cost-benefit analysis. So what I did was, in these articles, I looked at the three most influential studies, and I looked at the data behind them and the methodology behind them, and what I was surprised to find, frankly, was that they just don't stand up. None of these studies have been peer-reviewed. Their samples are biased. They substitute ex-ante guesses for the costs and benefits of regulations and report them as ex-post actual costs and benefits. But most of all, they zero out whole categories of regulatory benefit. And when I actually looked at one of the most influential studies that have been widely quoted to promote this regulatory skepticism, I found out that 41 of the 136 rules in the database were assigned a zero benefit, not a zero net benefit, but a zero benefit, because the benefits that those regulations provided had not been monetized and quantified by the agency. They were qualitative benefits, like the benefits of freedom, like the benefits of enforcement. The list of zero benefit rules included rules to prevent major oil spills, like the Exxon Valdez, rules to protect 3.9 million agricultural workers from acute pesticide poisoning. Here, the rationale was that acute pesticide poisoning wasn't one of the harms for which we had detailed monetary value. So they zeroed out. All right. So the point is that these studies are not peer-reviewed studies, and I just would like to suggest that before we go further down the road of the OIRA intervention, perhaps the OIRA intervention itself ought to be subject to a cost-benefit analysis. Perhaps we ought to look at the empirical basis underlying the entire project of White House intervention in expert rulemaking. And let me just close by saying that I don't want to be interpreted as saying that there's nothing wrong with agency rulemaking, that there are no bad rules. There are. I suspect, though, that when you look, you will find agencies making errors both in under-regulating and over-regulating. There's not a skew. But in any case, the way to correct bad rulemaking is public involvement. It's expert involvement. It's transparency. It's openness. And unfortunately, this executive order is not about public involvement. This executive order is about building OIRA's turf, and therein lies the problem. Thank you, Mr. Chairman.
Thank you. I want to ask Professor Strauss questions early because I understand he may need to leave, but I wanted to ask first a question of Dr. Bass because it was part of his testimony addressed some of issues I've been thinking about myself. You discussed a reporting requirement to show what rules proposed rulemaking was presented to an RPO and the RPO said no or adjusted it before it went forward. Who talked, who was involved, all the things that Mr. Rohrbacher seemed to think was suggesting sinister motives, but just in the interest of transparency. It doesn't seem unreasonable to know what agencies of government are, what they're deciding and why they're deciding it, and who's involved. But you suggested it be once a year. Why that infrequently? It seems like many of these decisions, if they're to be challenged, a decision not to go forward with rulemaking, if that is to be challenged, it should be challenged much more quickly than once a year. You could easily have an 11-month period.
Yes.
Dr. Bass.
Well, I completely agree with you, Mr. Chairman, and in my haste to speedily move through an oral statement, I mushed together many items, and that's a technical term, mush. I do think that what needs to happen is there needs to be a proper record established at the agency so that these RPOs are held accountable, and that would mean ongoing review. What I was suggesting to help the public is through the twice-a-year unified regulatory agenda that's published in the Federal Register, there should be a section on items that were permitted to go forward, items that were not permitted to go forward, and a justification why. The annual report should go to Congress, and you may seek to have it even more often, but that annual report should also get into what changes in those that were going forward, what changes were proposed in going forward, along with the documentation from the civil service staff that was transmitted to the RPO so that you have a record of all of that. And let me just say, what we're talking about, Mr. Chairman, is mini OIRAs. This is through this RPO system, and the connection of the RPO to OIRA creates the equivalent of a OIRA on steroids. So it's essential to do what you're saying, and I realize it's a burden for the agencies, and I realize we're running up against things, but it's essential.
Professor Strauss, you raised great concerns about the statutory authority for RPOs to be given the authority, the powers that they are. What remedies do you see that are available to Congress for RPOs to be acting beyond the powers that Congress thought we were giving agencies, or the executive branch in rulemaking? What can we do about it?
Sorry, this is a complex question in the world of politics, as well as law, because of course Congress doesn't act alone, and what you're talking about is a measure in which the president has a significant, I might say, personal political interest, so that whatever Congress might decide to do either has to meet the president's willingness, or you have to be able to do it in a fashion that he can't resist you have to be able to override a presidential veto, or perhaps you have to do it in some form where he's obliged to accept the whole package, and this bit of remedy goes with it. I would suppose that if Congress were to come to the conclusion that regulatory policy officers had been authorized to do things that Congress had not authorized them to do, and that congressional permission was necessary, one straightforward thing to do would be to provide that in the annual budget no funds could be expended for these inappropriate functions. That is a kind of measure that is frequently found in other contexts, in appropriations measures that the president signs on to. He wouldn't like it. I don't think that's very good legislating in an important way, but you're between a rock and a hard place, it seems to me, and working out what I imagine might result from this would be some negotiations between the White House and the Congress in which one could come to an understanding about how the regulatory policy officers would function, including provisions for transparency. This has been the history of Executive Order 12866 and its predecessors. There's been a regular course of bargaining over time between Congress and the White House. The transparency provisions currently in 12866 did not get there by accident. They were very much the product of congressional prodding in the period leading up to the adoption of Executive Order 12866 under the Reagan executive order then administered by President Bush. It had got to the point where Congress refused to confirm a director of OIRA for a period of years on the understanding that we are going to have some bargains made about the way in which you exercise this authority. And those bargains were made.
My time has expired. It's my turn again. Professor Strauss, yes, I would imagine that that would be the subject of bargaining, but I've yet to see much bargaining. You saw some of it in the first panel when the witness said that this executive order was designed to enhance transparency, and I said, how did you decide that? He said, it's none of your business. Certainly, withholding funds is, as you point out, not the best way for Congress to impose its will, to just prevent the president from authorizing something, but politics is the art of the possible, and that is certainly one thing that may be possible. A question for anyone on the panel wishes to address it. I raised questions in my opening remarks about the criteria that were in this executive order for issuing orders or particular remedies, particular regulations, market failure, and then some elaboration of what constitutes the market failure. Does that criterion appear in statute? And if it does not, what is the authority of the executive branch to add that as a criterion in issuing regulations?
Well, I'm not sure that this will be a wholly satisfactory response. In part, in response to Congress's own wish to have this information, the President requires cost-benefit analyses to be done in accordance with the criteria that he has in mind. I don't myself find any difficulty with his asking for agencies to do that analysis. It can be helpful to the President in proposing legislation, in pursuing the priorities of his administration. It can be helpful to the Congress in understanding where legislation may or may not be needed, and at least if honestly done, I really do commend my colleague Parker's extended studies for their demonstration of how poorly cost-benefit analysis is sometimes done in the service, ultimately, of political ends. But if it's well done, it is an informative and useful means of analysis. For me, the difficulty comes, and I think this is instinct in your question, when one moves from acquiring information, from the consulting with agencies that the President is unquestionably entitled to do, to taking over decision, to telling agencies specifically what they're to do. When you pass statutes, You give agencies responsibilities, and you give agencies responsibilities within specific parameters. Not so recently, the Supreme Court made very clear, for example, that for the EPA, costs are not part of the statutory equation. Doesn't mean that EPA can't develop for the White House information about costs, can't even have discussions with the White House in which the White House's view about the importance of avoiding excessively costly regulations may be an element of the discussion. But the responsibility for decision is placed in EPA's hands, and EPA is not entitled, when making or explaining its decision, to consider costs. That's quite straightforward as a matter of law. So the issue is not so much not having the analyses made as making clear where it is that the responsibility for decision lies, and that decisions have to be taken without regard to these statutorily inappropriate factors.
Professor Parker.
Yeah, I might just add that I think with regard to your specific question about market failure, whether or not this new language is problematic, I think would depend a lot on how it's implemented. That's kind of banal, but for example, any good lawyer, I think, who wants to justify a regulation could, within very broad bounds, identify a market failure that the regulation could address. Market failures abound around us. It's pretty low-hanging fruit. And there's also a savings clause in case you can't do it. So the regulation itself on its face is not facially problematic. The question is whether this signals an intent for OMB to come back and start engaging in a rebuttal process, a dialogue, a debate about whether there really is this market failure, how bad is the market failure, would the market failure be as bad as possible government failure, which is a standard, conservative anti-regulatory trope. And if that's what this is, if that's the intention behind this language change, then that is distinctly problematic. The language change itself, if market failure is an explanation that needs to be made and can be made unilaterally by the agencies and is taken by everybody outside, that would cause no problem to me. It's this question of whether it becomes a debating issue.
If I could add just three more points to the fine and important comments from my colleagues. One is, I know of nothing in cross-cutting law that requires a market failure analysis. There may be specific requirements in individual statutes, but there is nothing to my knowledge that addresses this, which raises a question about, again, the separation of powers question that you've been raising all day, of congressional authority versus executive branch authority. Second point is that what has not been mentioned about market failure criteria today, Mr. Aitken failed to mention that one of the changes in the new executive order is the last line, which is an assessment of whether any new regulation is warranted. That becomes dangerously close to what Professor Strauss was talking about as being determinative. And if this raises to the level of that, then this is extremely troubling. The third point is confusion. Agencies have to implement this in a few months. What the heck is market failure assessment supposed to involve? What we heard today is a repeat of three criteria that are simply listed in the new executive order. That doesn't help me clarify what it means to happen. It could be as absurd as the fact that the OIRA administrator, Susan Dudley, drives a hybrid. Is that an indicator there's no problem with climate change? I mean, I don't know what a market failure assessment will involve, and the agencies are left holding the bag now.
I think, well, I agree with, I'm not a witness here, but I agree with Dr. Parker's assessment that there probably is a role for something. Is the market going to take care of this? Are we fixing something that really is not broken? and in deciding whether to issue a new regulation, whether to address a problem by regulation. If it's a problem that's going to work itself out fairly shortly, fairly easily, there probably should be some discretion. But as Professor Parker, yes, I was getting to the but. As Professor Parker points out, it is a criterion that lends itself to seeing everything through a dogmatic lens. And there is a philosophical point of view that the market fixes everything. The market never fails. And that's the point I made in my opening remarks, or in an early round of questioning, rather. That was the debate last week. That will be the debate again and again on every issue where Congress is proposing anything new. Is the market's going to fix it if Congress will leave it alone? And obviously, when we act in the face of that, we're rejecting the argument that the market has not failed. The market will fix it on its own, which does make, I think, transparency all the more important. When is that criterion being applied? How is it being applied? So that someone may challenge it. If someone wishes to bring a lawsuit to say the agency should have acted and did not, that they know when it's happening. And I think all of you have made that transparency point in your testimony, and it's an issue that I raised in the last hearing on this topic. Professor Strauss, Professor Parker, you heard Dr. Bass's discussion of possible transparency fixes. Any thoughts of what? Do you all have any thoughts on how we can address transparency issues? Professor Strauss?
I think that it would be useful. I'm not sure it would succeed for the Congress to require OIRA and the agencies to follow what has in fact been the best practice that I'm aware of agencies under the executive order as it now is. The Department of Transportation, as you may know, has a really quite terrific docketing system for all of its rulemakings, into which every scrap of paper that they may get is either scanned or, if it's an electronic form, dumped. And if one looks at those dockets for the Department of Transportation, one finds accounts of the meetings with OIRA that are thorough and extensive. Who was there? What did they say? What did the government officials say? That's done at the Department of Transportation. As it happens, they have been running a particularly efficient and effective rulemaking process that probably not coincidentally runs into trouble with the courts a lot less than the rulemaking processes in other agencies. That should happen universally. OIRA doesn't keep the Department of Transportation from making these transcripts available on its website. I don't imagine that it would be resisted as a general matter, but OIRA isn't enforcing that either.
Professor Parker.
Yes, I would second that, and the suggestion of the people who, in the agencies who made the complaint that I reported, was that that an instruction be put out that basically is somewhat like the instruction that is there now, but extended into the the pre-regulatory initiative process. And I think that's what DOT is already doing. So it can be done. And I would also just offer a comment on the anticipated rebuttal, which is that, this will get into the deliberative process and we can't do that. It's ironic that first, the Department of Transportation is doing it. Secondly, I thought it was interesting that the OMB in this new executive order seems to be favoring or encouraging formal rulemaking, something we haven't really talked about. and actually exempting OIRA review from processes to go through formal rulemaking. But formal rulemaking, as you know, even though it's too cumbersome to be really workable because of its trial provisions, does have one provision involving ex parte contacts, which is a ban on them once things have initiated, which is directly relevant here. And I think it gives a pretty good answer to arguments that, oh, we must have all of these things, you know, in back rooms where people won't be able to be candid. You know, in that process, things are put on the record, and we don't consider that a faulty or a hampered or an impaired decision process because everything has to take place on the record. So I think that that there are answers to that, and I think the solution that Professor Strauss echoed is a good one.
Chairman, could I just add one more element to this?
Dr. Bass.
Ultimately, we always have to keep in mind why regulations are needed. We're first and foremost about protecting the public and our natural resources, and we tend to get lost in the discussion of the technicalities of the rulemaking system and forget about the end objective. In that context, transparency is critically important, but I also think that this committee and other committees in Congress really need to look at the panoply of analyses imposed on the agencies. This market failure criteria is yet another one. Mr. Melberth tested in your first hearing about a range of requirements that agencies have, what many have called paralysis by analysis, or Professor McGarity has called ossification. We have to look at that in the context of our objective to get speedy, responsive regulation done. Ultimately, what has happened, and is so central to what you're chairing here, is we find time and again now politics is superseding science. And the only way I know to address that is to talk about the entire regulatory process as something that needs to be opened up. That's why the guidance issue that's come up in this context of the executive order is troubling. If more agencies are turning to guidance, it's probably because the existing rulemaking system doesn't work that well from their point of view. And is then subjected to the same system, we're kind of going around in circle on this issue.
If I could just add one thought to that, the formal rulemaking provision is an invitation to another form of paralysis by analysis, and presumably this is the reason why the OIRA process is not regarded as being so important there. What it does is it delivers into the hands of those who might wish to obstruct rulemaking the procedural tools with which to do so, through cross-examination, through extended processes and the like. This is why it's not used anymore, is because it is a terribly inefficient means to make rules. But I do want to echo what Mr. Bass has said. One job for the Congress, perhaps not your committee, but another, clearly is to take the enormous range of provisions that have been adopted by executive order and by legislation requiring analysis of this issue and this other issue in the course of rulemakings, and to produce a somewhat more streamlined version. I don't think that's our work today, but it's a matter of enormous importance to the success of this mechanism.
I think that is all the questions that I have for now. Any of you have any valedictory comments? Professor Parker, Dr. Bass, Professor Strauss?
We appreciate you holding the chair.
Thank you. Thank you very much for being here. And you are no longer under oath.